Hey guys, welcome back. Today I've got a bit of a mashup for you. One of my favorite kind of mashups to do is Karen's in Court. Saucier are some of my favorite ones for the last month or so. I really hope you enjoy them, and let me know in the comment section which one you prefer the most. I want to thank you all so much for your support of the channel. To continue doing so, make sure and hit that like button, comment, subscribe, and definitely share these videos out with your family and friends if you think they'd like them. Other ways you can support the channel, down in the links down below, I have PayPal, Patreon, which I'm going to be putting stuff on that I can't put on YouTube. Got a lot of stuff in the works for that, which is actually pretty exciting. And of course, I have my merch store. Just bear in mind, this is the last week that you can get the original Irish Demon merch. I don't know what's going on with my voice today. Shouldn't have put the whiskey in that coffee. But anyway, this is the last week that you can get the original Irish Demon merch. All of the new stuff will be coming out next week. Just kind of polishing up a few bits and pieces on that one. So definitely have a look at that. And yeah, last time to get it, and also consider leaving a super thanks. Enjoy the show, enjoy the Karens, and let me know which one's your favorite. We'll catch you later. Sláinte. Hey guys, I hope you're all having an absolutely lovely Easter break. I'm at home at the moment, so that's why I'm not on camera. But I wanted to bring this one to you. It is so weird, frankly. I don't know what this woman's got going on. Maybe she's just trying to dodge having to actually pay her way or whatever the case may be. But check this one out. Let me know what you think in the comment section down below, and we'll catch you in the next one. I'm going to go to bed, and I will see you all tomorrow.
Slow down. I just want you to answer my questions. I got a busy docket. Did she give you her social security number?
She said the number, but I have reasons to believe that she's lying because she lies about everything else.
All right, wait a second. All right. Why do you think she's lying about what her social security number was?
Because when we were in the break room and she was supposed to answer questions, I asked her some questions that I know she was lying about, like, what's your middle name? She said, I don't have a middle name. And she has a middle name.
Where's your tax returns?
Oh, I don't have them with me today,
Why
because I
not?
gave them to them last time. The only thing that I was missing was my social security card, and they
Wait a
have,
minute. Did she send you the tax returns last time?
With everything blacked out. And that's why we had to do this again.
What do you mean with everything? Wait a minute, wait. What do you mean with
my
that?
current address when I came up here. And
Why did you black it out?
they have been harassing me. They've been,
Ma'am. You're playing judge and jury. You don't get to do that. I feel like I'm babysitting toddlers right now.
Your Honor,
Ma'am.
I'm so stressed out from this right now. They have done this to me.
Well, wait a minute,
Here.
wait a minute. So I gotta tell you though,
I just can't handle this.
ma'am. You got a judgment against you for $5,454.75 that was entered 14 months ago.
Yes,
How much of that have you paid?
I paid 2 months and then I went on medical because I had,
Slow down. I didn't ask you that.
okay,
How much of that amount have you paid?
maybe $300.
All right, so you're still 51, if that's true. You're still $5,154.75 in arrear, and if you only pay $300 a year, it's gonna take you 17 more years to collect the amount that you owe. Okay,
Can I speak?
no? No. Don't shake your head,
I wasn't working, Your Honor. We,
ma'am. Are you working now?
I just got back to work. They're calling the courts on a daily basis, talking to my probation
Let's just
officer, the
everybody-
landlord. They have copies of everything.
You were off work for 10 or 11 months? Is that true?
Since October, yes.
Well, that isn't 10 or 11 months. October was 6 months ago. And you just told me you got back to work.
Yes. The last payment I paid was October 20th.
Where do you work?
Next care, urgent care.
Do you have information supporting that, you two?
We don't have anything like without being blanked out from her. We have nothing. We have the questions she answered and we don't know if they are true. We don't know when she tells the truth.
Where do you work now?
Next care.
Where's it located?
I have two.
You might want to write this down. You have two what?
I have two clinics that I go in between Dundee and Ann Arbor.
Next care, urgent care?
Yes, sir.
Where are the two businesses located? And I want you to go slowly so they have the ability to write this down.
It's Dundee,
What's the address?
100 Powell Avenue,
Spell
100, and then Powell, Powell.
it. And that's in Dundee. And what's the zip code?
48131.
You have another place.
Yes.
What's that?
3820 Washtenaw Ave.
3820 Washtenaw, WASHTENAW. That's WASHTENAW Avenue. Is that in Ypsilanti?
Ann Arbor.
Ann Arbor. Two different words. Zip code.
48134.
48134. Okay, now. Why did you take it upon yourself to darken out everything on the tax? What did she darken out on the tax returns?
Her social security number, her employer number, her address.
Why did you do that? Who said you could do that? Did somebody tell you you could do that?
When I was at the
Okay, go ahead.
when I was getting copies up here that they were sending to them, because there's a no contact order from the probation side. This is a landlord tenant issue.
Wait a minute.
This
Is there a criminal case?
Yes,
You
There
were
are two-
prosecuted?
for something totally different, yes. I'm currently on probation, Your Honor.
And they're the victims?
Yes, this was a landlord tenant issue, which is all this started.
You're on probation for?
Disorderly persons,
Is that to me or to the other judge?
Hesed. They're calling the probation officer on a daily basis, they said.
Man,
I'm sorry, Your Honor, I'm just.
they have the right to be paid.
I understand that, but are we, I mean, how many times can we go to a discovery?
How many times,
It's changed.
why did you take it upon yourself to darken everything out?
The secretary did up there. I asked her, do I have to give them my phone number? I mean, my current address, because
Did somebody tell her she could darken that out to your knowledge?
they did it. I didn't
Ma'am.
even- Sorry.
Did
I'm
somebody-
not aware of that, Your
Who's
Honor.
they?
Whoever had sent them for me at the cashier there, the first discovery back, this was back in,
They have the right to be paid,
I understand that.
okay? They have the right to be paid. Now, we can do one of two things. You guys can garnish wages. And you can garnish your tax returns. If you have true reason, legitimate reasons to believe that the social security number that she provided, and please don't say it, we're on YouTube here, is incorrect, then tell me why you believe that other than she lied on other things.
Well,
Yeah.
for a manager name from
Gotta go a lot louder, a lot closer to the device.
last time when I asked about a manager, who is your manager at your work? She said, I don't have a manager. I asked about her middle name. She said, I don't have a middle name.
You know her name, ma'am?
Absolutely, Marie, and they have a copy of my driver's license
Marie, do you have a copy of her driver's license?
and my social security card. When I applied for the application to rent their property, the reason why we're
No,
here.
no, 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 no.
We don't have a copy of it, Your Honor, or we wouldn't be asking for it.
You're making this difficult. You're making this very difficult. I don't know why you are being like this, acting like you're the victim here. You have the legal obligation to provide them with this documentation. It's not my rule. I don't write these rules. But you're making it very difficult. Now you're talking about how you provided them with a social security card at the time that you signed up for a lease, which was what year?
Last year, 24.
All right, but Nothing about this discovery subpoena said if you provided them with these documents at the time that you executed the lease, you don't have to bring them. Did I sign something like that?
No,
Then stop acting like a victim. They're gonna get their money.
I understand
They're
that.
going to get their money. Okay, they have the right. If somebody owed me $5,400, I would be pursuing it as well, and so would you, and so would anybody else that's listening. Unless they're trust fund babies. Okay? Now, I don't know what to tell you. Except do I have to really babysit this and get everything that you emailed them? Did you email them all this information?
The first two discoveries that we had in the last 6 months, yes.
I didn't know that. I don't remember anybody telling me that there was no contact provision. I don't, maybe if I was told that at some point, I certainly don't remember being told that, and I certainly,
I believe that was in September was the first discovery, and then the second one was 2 weeks ago. And then that's when we had come back from the breakout room, and you had asked Mr. Street, where Miss Nicole was.
here's, listen to me very carefully. You can provide. Okay? Right? I'm rescheduling this to May the 12th, and I'm gonna make it at 11:15 a.m. Okay? That should give you time to get up, guys, time to get up and get your shirt on, Mr. Stupid, okay? In the meantime, you can send everything that was sent to you to the civil department. Okay? I want you to email plaintiffs to email everything that was sent to them, everything that was sent to them to the civil department. Now, where do you want us to send that, Lisa? I mean, Jennifer, jeez. Linda. Where am I
You can
sending?
send it, you can send it to mine at linda@33court.com.
Linda@33court.com. You guys writing that down? Write it down. I expect you to send everything to me, to the civil department
And that's LINDA.
at 33court.com. Send by the 28th. We're rescheduling this to May 12th at 11:15. I will expect that everything contained herein you're gonna bring with you in hard copy this time.
Your Honor, I'm
Yes.
sorry to interrupt, but you are not here on May 12th.
Never mind.
How about May 6th?
That's a Tuesday, right?
Yes, because
We can do May 6th. May 6th at 11:15. I'm gonna expect that everything that they requested in their initial subpoena, that you will bring a hard copy. And this is silly that we can't agree on what was sent. That's what I'm doing. Have a great day. Send everything over that she sent you. And you're going to bring copies of the emails and the attachments that you sent to them.
Okay.
Okay? Let's stop this nonsense. In the meantime, you can, if you choose to, have a writ of garnishment issued for her wages. Okay? That's all I'm gonna say. Everybody have a wonderful day. I will see you in a couple weeks. Thank you very much.
Your Honor, are you signing the writ today? For the garnishment? Or is that separate?
I don't sign anything. They're gonna submit it.
I just need to know if I have plenty of my doses.
If you want, you can file an installment payment order.
That's what we have for $65.
When was that at?
That was the first hearing. This is the third discovery. This was the first discovery in September.
She stopped making payments on her second payment.
And I made the payments up until October 24th.
Slow down, please. Do I have a installment payment order on this? I don't see that I do. Maybe I do, Linda, is there an installment payment order somewhere?
Let me check, Your Honor.
Yeah, I entered one on $65 every 2 weeks, starting October 21. You need to file a motion to set aside the installment payment order before you do anything.
We filed that.
When did you file it?
Let's see here, I think it was about 2 months ago because she just stopped making payments and never paid again. She made the first one and stopped.
Did I ever sign an order setting aside the installment payment order, Linda?
I'm checking right now, Your Honor.
Take your time. I mean, this has been going on for quite some time now. I told you after September 24th, about at least.
Your Honor, you did. On January 30th, there was an order to set aside the payment order.
So there's no installment payment order in effect, so you can feel free to garnish your wages, okay? And that's it. You gotta pay. Make it as painless as you can. But you're going to pay.
So, Your Honor, do I need to bring documentation showing the reason why I stopped paying? Because I have in the hospital.
You respond to the motion to set aside the installment payment order. Listen, you're way past. You're way past that.
We're on the third discovery, yes, you are.
Forget the discovery. I entered the judgment in February of 24. This is April of 25. That's 14 months. You've only paid $300. If you paid $6.50 a pay, you'd have paid $300. Right?
And
Your Honor, that was not from 2024, February 24.
The judgment was.
That was the landlord tenant. That was from the
Let me
landlord.
double check.
Okay,
Let me double check.
because this was just September 24 that we set the installment.
And she did not pay $300 in this case. She's counting with the money that,
6th of 24. 13 months.
That was prior to the installment. The installment was ordered on September 24th of 24.
Okay, so you've still had 7 months where you've only paid a total. You've paid $300, ma'am, in 11 months.
I was going through the criminal case and paying 362 a
You
month.
can't just ignore an installment payment. You cannot just ignore an installment payment without taking some action. I'm sorry. I wish you well. We'll move on to another case. I told you I'm going to proceed. You come back here in the date that I gave you. Good luck.
Thank you.
Susan Hannah, versus Teresa Segura.
I'm in fear for my life.
Judge is talking right now. That means you don't interrupt the judge. Do you understand what I'm saying? I don't even know what this is about.
Boy, oh boy, do we have a bit of a Karen here. This chick is absolutely painful. I did some digging as well, and I found some very, very interesting things, including a very interesting video from one of her family members. This lady's got a lot of history. A lot of history. Turns out she's got a history of dumping tires all over the state of Michigan. Allegedly now, of course. Keep your eyes out for the crocodile tears that immediately disappear at one point, and you'll see exactly the kind of woman I'm talking about here.
We're going to jury trial and a false information to a police. Mr. Baldwin, I need you to zoom in, please. What's going on? I need you to zoom in. Can you state your name?
Attorney Mike Baldwin, P 65417, on behalf of Ms. Cosby.
Were you working on another case or what?
Yeah, I have 2 things going here, but I'm also with Mr. Shrum here as well. So I actually have 3 or 4 things going.
All right, listen. Are we serious? We're going to a jury trial and a false information to a police officer.
My client takes a position that that she reasonably believed that there was a firearm in that vehicle, and I can't refute that. And I offered her a bench trial, Judge.
Good enough. Good enough. Good enough. Good enough.
And I do have my calendar.
I thought it was just a regular. I didn't know. I shouldn't have assumed that. Usually they gave the wrong name. That's fine.
Yes.
Ms. Foley
And
Carter, I need in here. Ms. Foley
Yes.
Carter, can you come in, please? We're gonna set a jury. I get it. Your name?
Caitlin Fuller.
Jury trial will be scheduled right now.
I have my calendar, Judge.
May 9th at 8:30.
All right. Well, this is just, we're just starting this case, really, right? Well, no, February 27th. Ms. Cosby, you got to be here in person. You understand that?
Yes, I understand that, Your Honor, but am I allowed to put anything on the record right now?
About what?
About
What do you want to put on the record?
My life. I'm in fear for my life from Justin.
Your Honor,
Fuller.
I've advised her to seek out a PPO, but it was
For my
rejected.
life.
Hang on. Hang on.
Your Honor, may I say something, please?
No,
Since
no,
my
I don't even know who you
court
are. Hang on. I said, wait. The judge is talking right now. That means you don't interrupt the judge. Do you understand what I'm saying? I don't even know what this is about.
I don't need.
Hang on. Don't say a word. What's your name? Sir?
I'm Justin Cole, I'm the victim. Your Honor.
I know, but what's your name? Justin Cole?
Justin, yep.
What in the world is going on here? I thought this was false information to a police officer. Miss, can you enlighten me? I don't know.
It is, Your Honor. Ms. Cosby and Mr. Cole are both at the police department. Ms. Cosby called the police and told them that Mr. Cole pulled a weapon on her outside in the police department parking lot. They reviewed footage. There was no firearm. They searched Mr. Cole's vehicle. There was no firearm.
Okay. All right. Well, you don't need to put anything on the record. If you want to get a PPO, you get a PPO.
Well,
I'm not going to, hang on. Well, I wasn't done talking yet. I'm not going to engage in this colloquy here. I've got one charge in front of me, false information to an officer. If you think you're in fear and he's stalking you or doing anything else or aggravating you to the extent that you'd be entitled to a PPO, go get a PPO. Mr. Baldwin already said, hang on, I wasn't done talking yet. When I stop talking, I'll tell you. How's that?
Sorry, Your Honor.
Now, I'm setting it for a jury and I'm setting it for a final pretrial, and that's it. And you have to be here for the trial. Where's Johannesburg again?
I know that one. South Africa.
By Gaylord. And what's the date, Your Honor? Because I have other court dates with my father through probate.
We're going to give you a date right now. We're going to give you a date right now. All right. Wait a minute, guys. I'm not going to, you guys are not going to get along with me if you're going to interrupt one another and engage in this. I'm telling you. I'm telling you right now. We're setting a jury. She wants a jury. She's entitled to a jury. And that's what I'm going to give her. I just thought it was a simple misuse of a name or something, or giving the false information as to a name. This is a little different, but I don't want to hear any of this.
May I ask you something, Your Honor?
Sure. I've got a no contact provision, I think,
Yes,
don't I? Maybe I don't.
That's what
One place, Your Honor.
That's what I was hoping, Your Honor, that you would give me a no contact with her, because she keeps calling and calling. I mean, I don't want no more calls, false calls, please.
Yeah, I didn't realize what this was about. It was rain. There's no, Ms. Foley Carter, you know what I've been trying to do for like 30 years, 28 years? What do you think I've been trying to do on these?
What's that, Your Honor?
I've been asking them to put information on a ticket. I've quit. Hang on. I've quit asking. It falls on deaf ears. I've asked police departments through chiefs no less than 25 times to put simple, basic information on a citation so I can have some idea as to what I'm talking about when I'm doing a bond. False information to a police officer. That's what he wrote. Just a simple, maybe you can help me with this too, Mr. Foley. Just a simple, just a simple, whatever it is, gave false name of Jane Doe, went into Myers, stole $1,000 worth of property. punched and slapped the victim. I mean, I don't know what else to tell you, but I got to chase these guys around. I'm looking at a citation. I'm not reading police reports when I'm doing these. And
If I may, there is a misdemeanor complaint in the file.
I see it now, but I'm getting like 50 cases a day. I mean, I see that.
Your Honor, we can take it up with the department once again.
I know, but listen, it's not just Brownstown.
All I can do is check.
What happens is guys retire and they don't tell anybody, and the new guys don't tell anybody, and the new guys, and I got to keep doing it. It's just getting aggravating, but nonetheless, I'm going to order, give me a bond sheet, please. Ma'am, you're going to have to go get printed if this is the kind of case it is. I'm sorry. So I'm going to have you come here next time. You're going to have to come here next time to get printed by Brownstown. And I'm going to order no contact with the victim, Justin Cole. No contact with Justin. No contact with Justin Cole. No contact with prosecution witnesses. And you cannot. You have to go over to the Brownstown Police Department to get fingerprinted and photographed on your next court date. When are we going to have the next court date? Can we have it on the
April
23rd?
23rd at 11.
So I'm going to say you have to be there by 2 o'clock on April 23rd, okay? And then we're going to set a jury trial date. I'm not adjourning any of these dates again. Mr. Baldwin, what do you have? And Ms. Foley Carter, are you guys good on just give me a date in May, a Friday in May when you can do this.
I'm available
Except
in
the
the
2nd. You available on the 9th? May 9th at 8:30 will be your jury trial date. All of this will be in person.
Your Honor, I have a probate court date on my father that day.
She does not, Your Honor. I have power to attorney my father. She does not. That's a lie. Sorry.
If I find somebody starts lying to me,
Your Honor, I'm not lying to you.
There's no probate.
send me
date.
the notice.
It's not on the 9th, it's on the 10th.
Stop.
It's on April 10th.
Wow.
Stop. Do you have a court date, May 9th?
It's May 9th, yes.
Where?
April,
What court?
April 10th, emergency hearing at probate court, and then
That is false.
Don't say anything, Mr. Cole.
Sorry, Your Honor.
I'm sorry, Your Honor, it's May 6th. I'm sorry, it is.
Good.
I just
Then
got
you
the
don't have
court date.
anything May 9th.
No, May 9th is good.
No adjournments of any of these. So if you get another court date, you tell them the mean judge in Woodhaven won't adjourn it. April
What time,
9th at
Judge?
11. I'm sorry, May 9th at 8:30. Final pretrial will be April the 23rd. And I'll make that later out for you so you don't have to show up so late. Did you tell me 11, Lisa?
Yes, 11 o'clock.
And you have to be over, so no contact with the victim. You have to go over to get photographed and printed by Brownstown by 2 p.m. on April 23. No contact with prosecution witnesses. And I am ready to go. That's it. Have a nice day. Good luck. I hope you guys will continue to talk. If not, we'll see everybody on April 23rd and May the 9th. Thank you.
Thank you, Judge.
All right. Do I have anything else that's right?
Interesting how the tears just magically stopped, isn't it? So I did a little bit of digging, and I'm going to show you what I found. So I won't say the name of the website because obviously I don't want to be causing any trouble here. But basically there is a video of this lady being confronted by, it seems, her brother for more of the same false police reports. There's a whole load of other stuff on there as well. So let's have a little look, shall we?
Now, you just lied to a police officer that I threatened you, right? Everybody here knows you just lied. So, yeah, that's a false police report you're making.
Thank you.
Now, that's a false police report you just made right there. Good. I know what's threatening you. Who threatened you? What did I threaten you with?
Listen, Justin.
You're a psycho is what you are.
I'm here to see you.
Good. You come here to raise hell with him, and you ain't gonna fucking do it. I'm stopping it. You guys ain't gonna keep pushing. You guys ain't gonna keep fucking with him. Yeah, really? Really? You got 150 grand, yo? You got his money? Do you have his money?
Listen, bitch.
I got you on 50,000 in steel scrap with your IDs in Metro Shores account. Do you have that? Do you have that? Do you have that?
Shut up.
You don't, right? So
We'll
basically,
see
fuck
it.
him.
We'll see about
Yeah, and you'll
it
see some
before.
forged signatures that you guys are signing on me and Dad's behalf. You're
We'll
going to get
see
some deep
about
shit.
it. You and Dad.
You guys are the biggest bums.
You
We'll
and Dad.
steal some houses. You fucking can't react like I'm somebody. Over here, fucking ripping people's fucking houses off. 3, 4, 5. You sure you don't want 1,000?
No, I don't want 1,000. You don't want. Take my baby something for Christmas.
Why don't you want 1,000?
I don't want this shit rob me for it.
There's no need to cry. You hear me?
Yeah.
Everything's gonna be fine. You know the truth. We know who took your money.
Yeah.
We know who stole from you. Lisa and Steve got how much from you?
No,
Huh?
it's a shame.
We know the truth, and that's all there's to it, right?
Yeah.
Scrapped all your stuff, stole all your stuff.
Yeah.
What Steve tell you when you wanted the money back over there?
Huh?
What Steve say when you wanted the money when you asked him about the money here the other day?
Tell me fuck you.
Fuck you. And when Lisa said it to him, let it go down, right?
Yeah.
Didn't say nothing to him?
Nope. She's in on it.
Huh?
She's in on it.
Yeah. So is Mom.
Yeah.
It's a three-way street. They all get paid off your money, and you sit here broke.
Next time.
Now today's the 23rd. There's the 22nd now.
Huh?
Today's the 22nd. You get $500 there.
Right.
Right? 2020, 22nd, 2020. You got $500 right there.
Right. Write it down.
Now, you make sure
Right.
you don't let her have it, right?
Right.
Got you sitting here fucking broke. Got you sitting here broke and got $1 in your pocket. Can't even order food, can't do nothing here. And it's all your money.
Yeah, I know.
Well, I'm not gonna let it happen. It's not gonna go down like that.
Yeah. Take my baby and get him something for Christmas.
Don't be. Why are you upset?
I don't know.
Because that's the first little bit of money you've had in forever? Is that why you're upset?
Yeah.
Fella. That's heartbreaking to watch. Obviously, I'm going to blur this out.
Take the girl and get him something for Christmas instead of
No, that's your money. I'm not gonna spend the money on that. I don't.
still get him something for me.
Yeah, they've already got money from you. They don't need no more from you.
Like, what's really sad about this is like this man has been robbed blind by his daughter, allegedly. And evidently based on previous charges and all that kind of stuff. The caption in this one is that she went off on vacation and basically rubbed it in his face after stealing all of his stuff and all of his money, her own father. This is like a parody Facebook, basically. And then simultaneously on her own Facebook, she has pictures up about her father and how lovely and blah, 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 blah. So evidently this lady's an absolute piece of human shit.
Okay, and they're not gonna get it. I'm not gonna let no one have it but you.
Right.
You know what me and you've done. Worked our ass off and hand over to them. They just take from us.
That's so sad.
No, people, you're all fucked up.
And like after all of his money being taken, all he cares about is using the money that he was just given to get something nice for his grandkids. So I think it's safe to say that she's an absolute arsehole. Anyway, lads and lassies, I hope you all have an absolutely wonderful weekend. It's beautiful weather out there again today. I'm going to do a couple of videos here and then I'm going to hit the road on the old Harley and have a nice weekend. We'll catch you in the next one. Sláinte.
Anybody listening to this knew you weren't going to agree.
No,
Hang on.
all the people that I work with feel like it was petty. All
Time
the people
out.
that I work with feel like it was petty. And even
Young
the
lady,
report,
do not
the secretary at the court.
interrupt me. Do not interrupt me.
Am I free to speak or not?
No.
Because I asked him when he pulled me over specifically because I was praising God. I was in praise and worship, listening to a specific song, and I asked him. I said, "Excuse me, can I ask you why I'm being pulled over?" Because
this one gets hot very quick. Now, I'm all for people arguing their case in court, of course. That's what it's there for. Especially if it's really, really serious stuff, and even more especially if you actually didn't do what they claim you did. Now, this lady literally admits to doing what's claimed here, but she thinks that she should have got a warning, even though we find out later she already got 2 warnings for 2 other infractions on the same day. Then again, she was listening to the word of the Lord, specifically a certain song, and thinks that she felt like she should have got a warning, even though her friends told her that it was petty. Feels pretty petty. But check it out, let me know what you think. Is it petty?
Angel Tierra Murkerson, file number 25B148321, and it should be Officer Paul. Good morning, how are you?
Good morning, Your Honor.
Your name?
Officer Paul, Brownstown Township.
Where is Ms. Murkerson? You're gonna have to start your video, please. Bottom left-hand corner of your screen.
Yes, Your Honor. Angel Murkerson.
Okay, stay right there. Who are all these people around you?
I'm at work.
So I want to just see you and we'll go from there, okay? The officer is here. He's ready to have the hearing. Do you still wish to proceed to the hearing, ma'am?
yes.
I'm going to ask you, officer, and you, ma'am, both to raise your right hands. You solemnly swear affirm under penalties of perjury that the testimony you will give in these proceedings will be the whole truth, so help you God. Officer?
I do.
Ms. Murkerson?
Yes, I do.
Okay, go ahead, officer.
On March 18th of this year at approximately 9:03 a.m., I was on patrol in Brownstown Township, working in OHSP seatbelt detail. At that time, I observed Ms. Murkerson operating her motor vehicle wearing her seatbelt underneath her armpit and proper use of her seatbelt, and she was cited for the same.
Any questions of him?
You say questions. Are you asking me, Your Honor?
Yeah, do you have any questions of him, of the officer?
No, my only question was, my concern was that I had on my seatbelt, and I told him me reaching for my beverage, by me being short, my seatbelt naturally wants to come here. And if it's over my shoulder, when I go to reach for my drink, it's in the way. So I thought it would be just a warning. I'm like, I got a good driving record. You know, I did have my seatbelt on, but that was my only question.
But you can't wear it like that though, ma'am.
I don't wear it like that. I was just grabbing my beverage and I literally had put my seatbelt under my arm. Like I said, I felt personally, this is me, I'm not saying that it's right, but I felt like that should have just been a warning, being that I did have my seatbelt on, when there's people that don't wear their seatbelts at all.
Well, that's not a defense. I mean, the fact that some people choose to violate laws.
But my defense is I was practicing the law. It's just that I did, as he said, okay, but it wasn't on properly. It was buckled. If I had had it holding it with my arm, but it really wasn't buckled, then I feel like that would have been okay, that's a violation. I didn't know that me putting it under my arm to reach for my beverage would cause me to get a ticket. I had no idea. So to me, I didn't see them give people warnings for lesser things. My seatbelt was buckled up. It just wasn't across my shoulder when he.
You're not wearing it properly, ma'am. That's not wearing it properly.
Your Honor, if I may
Yeah.
speak to, she did receive 2 verbal warnings, one for her plate or vehicle showing no insurance on it, and she received a warning for a tinted license plate cover.
My vehicle had insurance from the date that you pulled me over before then.
Wait. Let him finish.
Oh, okay, okay, no problem.
Wait.
So again, when I ran the plate during that traffic stop, it did show her vehicle was uninsured. I did not confirm or verify that because I wasn't taking action on it. She was receiving a verbal warning for it anyway. But from what I could see in my system, it was showing that her vehicle was uninsured at the time, which she did receive a verbal warning for, in addition to the tinted license plate cover that she had.
Okay, now can I speak?
Yeah.
Okay, so I have another vehicle that was registered under the same plate. So I guess in transference, the state probably didn't have it updated, but I definitely had insurance. He never asked for a copy. So to say that I got a verbal warning, he never asked for my insurance to see if I had it or not. So I don't know how, because I have proof of everything. I made sure of that. I don't drive a vehicle without having proof of insurance. I couldn't take that car off the lot without proof of insurance. The only thing he asked me was that car mine. And I said, yes, this car is mine. It's insured in my name, and I am the only owner. I never got a warning about anything with insurance because we never discussed my insurance because that was never the issue. The only thing that officer stated to me was that because I asked him when he pulled me over specifically because I was praising God. I was in praise and worship listening to a Pacific song. And I asked him, I said, excuse me, can I ask you why I'm being pulled over? Because
What's a Pacific song? Is it like Hawaiian music or like, you know, luau kind of shit? I mean, just asking you specifically, like I don't know what Pacific song you're talking about here. And specifically, why did you think that telling the judge that you were praising God would make you get away with this somehow? Not being very godly right now, are you?
Because I asked him when he pulled me over specifically because I was praising God. I was in praise and worship listening to a Pacific song. And I asked him, I said, excuse me, can I ask you why I'm being pulled over? Because I thought I was following all proper protocol. I knew my car had been registered. I knew that I had just transferred it from another vehicle off the plate at the dealership. They said that I could use the same plate and everything was properly done. I had all that proof in my glove box. I had my insurance. So I knew I wasn't being pulled over for those reasons. So when he said my seatbelt, I was shocked.
Ma'am, did you
Yes.
hear me? I was trying
Yes.
to stop you. Why weren't you stopping?
I didn't hear you say ma'am. I hear you now.
Okay, good. All right, so listen. That insurance, I don't even need to hear about it. I don't need to hear about the tinted window. He didn't write those, but you're responsible of seatbelt violation. I'm sorry. I find you responsible $65. Can you pay that today?
No, I cannot.
When can you pay it?
I don't. I'm unsure.
Where do you work?
At a hair salon.
Well, you got to give me a date when you can pay this, ma'am.
Am I able to fight this further? Because I don't agree.
Yeah, you can pay.
Okay. Well, I
Okay.
would like to do that because I don't agree.
Ma'am, anybody listening to this knew you weren't going to agree. Hang on.
All the people that I work with feel like it was
Time
petty.
Time
All the
out.
people that I work with feel like it was petty. And even
Young
the
lady,
court,
do
the
not
secretary at the court.
interrupt me. Do not interrupt me.
Am I free to speak or not?
No, you're not. I've already heard you. I heard everything you had to say. I'm not about to argue with you.
I'm not arguing with you, sir.
So,
I'm an adult just like you
gonna ask
are.
a question, and I'm going to tell you the answer. You can appeal this decision. You have to post a bond. Is it 7 days or 14 days, Lisa? Remind me.
I believe it's 7.
May 1, you have to pay by, and you tell them, I want to appeal that decision. You pay your $65, and then they will set it in front of the other judge, and you can tell the other judge your story, and maybe she'll agree with you. I don't know what else I can tell you.
That's all I need to hear. You don't have to tell me anything else. You have a wonderful day.
By May 1. Good luck to you. Thank you.
God bless you.
Yeah, thank you. Devon Michael Hoff.
Thank you, Your Honor.
What is happening in this world? People think they can argue about everything.
That's the thing, like, you have to pick your battles. Look how much time she wasted in court over what was a really small ticket. Yeah, it might suck getting caught just when you're doing something. You know, you hear it all the time, like somebody just picks up their phone while they're driving to check something. You're not supposed to do it. You get in trouble for it. No big deal. You take it on the chin, you move on. She just had to argue pacifically everything. It's like, you already got away with 2 things. Like, you already got just warnings for 2 things that you also tried to argue. I actually fell foul of that myself about 6 months ago. I got pulled over by the cops because there was something wrong with my tax on my car. They let me off with it. But then I got summons to court for no proof of insurance, but my insurance absolutely was in the window. Now over here, it's a little bit different. We have a little thing in the window that tells the cop that we're insured. Sometimes cops forget to check it. They have to tick it off the box. If they didn't check it and they say they did and it comes back that I didn't have insurance, he would be in a lot of trouble. So I had to go into court. The judge was like, were you insured at the time? I was like, yep, absolutely. Have you got proof? Yes, absolutely. Here you go. Thank you very much. Out the gap. Simple. You just deal with it. It sucks sometimes, but you suck it up, you deal with it. Anyway, there's just a really kind of a fun interaction immediately after this. Talk about being dressed well for court. This guy came full James Brown mode, hair, jacket, everything, and the judge likes it, so I'll leave you with that one. Sláinte.
Devon Michael Huff, 24T642304. Everybody else violates the law, so let me go. Give me a break. Your name? You posted a bond at 282, right?
Yes, sir.
Why'd you wait so long to take care of this?
Just been busy caught up with all that.
It's a nice looking jacket you got there. That's in your name. I'll tell you what, stop doing this, okay?
Yes, sir.
Just when I was about to pack up the computer for the day, I just happened to see this one happening as it happened. You can hear it playing in the background right now. It's this hilarious young lady who's a sob sit, and the judge is like, cool story, bro. It's absolutely epic. There's a lot of conveyance talk. There's a lot of right to travel talk, all that kind of stuff. I really hope you enjoy it. If you do, make sure and smash that like button, and we'll catch you in the next one. Sláinte.
Good
Yes, Your Honor.
afternoon, Miss Leslie. Miss Leslie, you're charged by way of information on or about May 21, 2025 in Butler County, Kansas, with interference with law enforcement, a Class A non-person misdemeanor. Count 2, same date and location, no proof of insurance, a Class B non-person misdemeanor. Same date and location. Count 3, no driver's license in possession, an unclassified non-person misdemeanor. Though, then count 4, same date and location, failure to register vehicle, and unclassified non-person misdemeanor. And Miss Leslie, do you understand the charges pending against you?
I comprehend the alleged charges against me.
Thank you, Miss Leslie. Miss Leslie, you do have the right to counsel if you cannot afford an
Excuse me.
attorney. Pardon me?
Excuse me, I was going to say that I comprehend the certain statutory allegations that have been made against me, but I cannot and do not admit to understanding or accepting the jurisdiction of this court over my person or the subject matter absent proof of corpus delicti and a verified complainant from an injured party. To do so would constitute a waiver of fundamental rights, which I explicitly refuse to waive pursuant to KSA subsection 60-212 and the doctrine of special appearance recognized in Kansas jurisprudence.
Okay. You do have the right to counsel if you cannot afford an attorney. One would be appointed to represent you. And Miss Leslie, are you currently employed?
For the record, Your Honor, just to start from the beginning, I, Sydney Taylor Leslie, appearing specially and not generally in propria persona, sui juris, as a living woman and not as a legal fiction or corporate entity. I reserve all rights without prejudice pursuant to KSA subsection 84-1-308 and UCC 1-308. Let the record reflect that my appearance today is under explicit protest and duress and solely for the purpose of challenging jurisdiction and preserving my unalienable rights as secured by the Constitution for the United States of America and the Constitution of the State of Kansas. And Your Honor, before these proceedings advance further, I must respectfully challenge this court's jurisdiction in toto and move for immediate dismissal of all charges. I hereby invoke the burden shifting doctrine established in State v. Shepard in 2009 and State v. Seams in 2004, which places the affirmative burden upon the prosecution to establish by sworn non-hearsay allegations within the four corners of a valid charging instrument that every element of the alleged offense and my commission thereof has been properly established. The threshold matter of jurisdiction must be adjudicated prior to any other proceedings. As articulated in Ex parte Young in 1908 and recognized by the Kansas Supreme Court, jurisdiction is the fundamental prerequisite to all jurisdictional proceedings. The legal maxim ex injuria just non autora, law does not arise from injustice, applies to these proceedings in their entirety.
Okay, and the court finds that Miss Leslie is appearing as a sovereign citizen before the court And the court, once
I
again,
object. I object to any of that derogatory. It's very biased. I move for immediate dismissal on those grounds and
court
disqualification.
overrules the motion for dismissal of the case. Court
On
overrules dismissal
this is
of the case.
prejudice and
The court will find that Miss Leslie, that the court does find it has jurisdiction to proceed. And subsequently, the court
I
sets your next
object. You
appearance
called me
date.
a sovereign citizen. I object. You called me a sovereign citizen.
Yes, ma'am.
That is prejudice and bias. And
No
it
prejudice or
declares
bias
for
is asserted
immediate
as to
dismissal of my
yourself.
case.
However, the court, as opposed to trying to write down docket notes to that effect, is just recognizing what you are advising the court, that the court has no jurisdiction over you, and based on your statement made to the court. Subsequently, the court does find you've posted a $3,000 cash bond. $3,000 cash bond has been made. Court does accept the same. And the court does schedule this matter next before Judge Webster on Monday, August 11, 2025 at 9 a.m. Monday, August 11, 2025, 9 a.m. before Judge Webster. Once again, Monday, August 11, 2025, 9 a.m. before Judge Webster. You do need to participate by Zoom process at that point. Subsequently, the court finds that Miss Leslie has not requested court-appointed counsel. Court does not appoint counsel at this point. The court does find that she has posted bond in the amount of $3,000 cash, $3,000 cash bond, and the court has scheduled her next appearance date before Judge Webster on Monday, August 11, 2025 at 9 a.m. Any other matters to come before the court, Mr. Sweeney?
No, Your Honor.
And Miss Leslie?
Your Honor, my jurisdictional challenge is predicated upon multiple independent grounds, each sufficient to warrant dismissal. First, I challenge personal jurisdiction pursuant to Kansas Rule of Civil Procedure. I appear specially, not generally, and have not consented to this court's jurisdiction. The record before this court is devoid of evidence establishing proper jurisdiction over my person as a living woman rather than a legal fiction or corporate entity, as distinguished in Hale v. Hinkle in 1906, and recognizing Kansas jurisprudence. Second, I challenge subject matter jurisdiction pursuant to Kansas Rule of Civil Procedure 60-212, B1. No verified complainant from any injured party has been filed as required by KSA subsection 22-2301 in Butler County Local Rule 3.1. The perpetrated charges arise from actions of agents of the state acting under a color of law, not from a legitimate controversy between adversarial parties withstanding as required by Article 3 jurisprudential principles adopted by Kansas courts in State ex rel. Morrison versus Celebius. Third, I challenge territorial jurisdiction. The alleged incident occurred after I had ceased operating my conveyance and was exercising my unalienable right to travel, placing it outside the territorial jurisdiction of traffic enforcement under KSA subsection 8-244, which by its plain language applies only to licensees who have voluntarily entered the regulatory framework. Fourth, the prosecution cannot establish the corpus delicti of the alleged offenses. As held by the Kansas Supreme Court in State v. Stern in 2015, the corpus delicti rule serves as a safeguard against convictions based on false confessions or statements. One cannot interfere with a peace officer absent of officer's lawful execution of duties. Where the initial detention was unlawful, as it was here due to lack of probable cause, there can be no derivative crime or of interference. Fifth, the refusal to provide identification is not a crime in Kansas, absent specific statutory circumstances not present here today. This is in support by Brown versus Texas in 1979. The Supreme Court held that detaining a person solely to obtain identification violates the Fourth Amendment absent reasonable suspicion of criminal activity. The principle has been recognized and applied by Kansas courts. In one moment, please, while I gather another statement. Okay, and another thing is, and this is, may it please the court, for the record, I must now enter an oral objection and motion for disqualification of the presiding judicial officer pursuant to Kansas Rule 2.11 of the Code of Judicial Conduct, as well as controlling principles under the Due Process Clause of the 14th Amendment. During a prior proceeding, specifically, this court referred to me by the term sovereign citizen, a pejorative classification which carries with its government manufactured implications of extremism, frivolous, and legal irrelevance. This label, unprovoked and unsupported by any factual predicate, constitutes a stigmatizing judicial characterization that violates my right to a neutral and detached tribunal. The use of that term demonstrates either a prejudiced bias or a judicial predisposition toward delegating the substance of my legal posture. As the Kansas Supreme Court has held, even the appearance of partially mandates recusal, and here the record reflects actual prejudice in open court. Wherefore, I respectfully move this honorable court to dismiss all charges with prejudice for lack of jurisdiction, issue a finding that the prosecution has failed to meet its burden of establishing jurisdiction, order the immediate return of all my property seized, including the 251 USD, confiscated and converted to a reloadable Visa card without my consent, order the expungement and permanent sealing of every associated record pursuant to KSA subsection 22-2410, award compensation for the full measure of damages sustained, including costs for my automobile window repair, bail costs, and compensation for unlawful detention and deprivation of liberty, grant such and other and further relief as this court deems just and proper. The breaking of my automobile window without warrant or probable cause of a search and confiscation of my currency constitutes violations of clearly established rights for which the law provides remedies pursuant to the maxim ubi jus ibi ridiem, where there is a right, there is a remedy. I reserve all rights without prejudice, waive none, and maintain my special appearance for the sole purpose of challenging jurisdiction and preserving my alienable rights as secured by the Constitution for the United States of America and the Constitution of the State of Kansas. And thank you for hearing me. I do appreciate you, Your Honor, and thank you for your time.
And once again, matter is set before Judge Webster on Monday, August 11, 2025, 9 a.m. by Zoom. There being nothing further to come before the court is in recess, and have a good day, Miss Leslie.
Thank you, Your Honor.
I don't care. I do not feel good. Do you not understand that I do not feel well?
All right. Ms. Reed, what is a good mailing address for you?
I do not have one at this time.
Do you have a telephone number?
Nope, not at this time.
Do you have an email address?
Nope, I have nothing.
And why is that?
I have nothing because I don't.
Where do you live?
I live nowhere.
I can see this can be one of these days. All right. How long are you in the Grand Traverse jail?
I just got here.
And are you in there on a probation violation?
Yeah, I guess so.
Good. Mr. Harrison, do you know why she's there?
I do not. I had to rely solely on her disclosure, and we got to the same point, Your Honor.
Okay.
I am aware that she will be assigned counsel up there, and I've advised her to have her counsel contact us.
All right. Ms. Reed, I have a complaint that alleges that on or about March 14th, 2025 in Cedar Creek Township of Wexford County, it is alleged in count number 1 that you did operate a motor vehicle while your license was suspended, denied, or revoked. That is a 93-day misdemeanor and or a fine of $500 with possible vehicle immobilization. Do you understand those charges and the potential penalties?
Yes, Your Honor.
Did you read and sign a device of rights form at the jail?
Yes, Your Honor.
Talk about your rights to a trial and your rights to an attorney.
Yes, Your Honor.
Did you understand those rights?
Yes, I did.
You have the right to be represented by an attorney at all phases throughout this process, and if you could not afford an attorney, one will be appointed to you at public expense, but you may be required to repay a portion of that expense. Today, do you plan to hire an attorney, represent yourself, or request the appointment of an attorney?
No, Your Honor.
No
I
what?
don't. What would I need an
don't
attorney
what?
for? I'm guilty of driving with without a license. Just get to the point.
Miss Reed, I
Well,
don't need
what
the
are you
attitude.
saying then?
I'm just asking the
I
question.
do not feel well. I can barely keep my eyes open. What is it? Life is going to be great for the greatness out there. So great. Because, I'm done sick of 3 times fucking being the same fucking month. And I'm sick of being shifted. I'm sick of fucking time still. I'm sick of being
Corrections,
fucking
please take her
retarded.
away.
Sick
We
of
will
my life
arraign her
being fucked
tomorrow
up.
when she's
Take
more.
Take my license. No, get it over with. Take my fucking license.
Okay.
Simple as that. Get it done and over with.
Graham
I have
Travers, can you
no
please
beginning.
remove her?
I
We
have
will
no
arraign her on a
beginning. I have
different
nowhere
day.
to start a new beginning.
I'm
I
not
have
going to
nowhere
arraign her today
start
because
a
I
new
do not
beginning.
believe she's in her right mind.
They don't sit in there too often.
All right, then we will get that set up with them
In my
later. We will
motherfucking right
remove
mind.
her
Let me
from
tell you what, honey.
the system.
Okay. Thank you, Your Honor. Wait for him.
A person at the Grand Traverse County Jail, what is your name?
My name is Rebecca Reed.
This is the people of the state of Michigan versus Rebecca Jean Reed, case number 25896 ST. We are here for a second attempt at arraignment. And Ms. Reed, I hope it goes much better than yesterday did. Ms. Reed, yesterday you indicated you did not have a mailing address. Is that still the case?
Yeah, I do not. I do not
And you
have
do not have
it.
a phone number or email. Is that correct?
No, I do not.
I know you met with Mr. Harrison yesterday by Zoom. I have a complaint that alleges that on or about March 14th, 2025 in Cedar Creek Township of Wexford County, it is alleged that you did operate a motor vehicle while your license was suspended, denied, or revoked. That is a 93-day misdemeanor and or a fine of $500 with vehicle mobilization. Do you understand those charges and the potential penalties?
Yes.
Do you know, did you read and sign an advice of rights form at the jail? Talked about your rights to an attorney and your rights to a trial?
Nope, I did not.
All right, let me go through those rights with you. If you require accommodations to use the court because of disabilities, or if you require a foreign language interpreter to help you fully understand and participate in court proceedings, please contact the court immediately to make those arrangements. You have been brought to court on a misdemeanor charge and you have the following basic rights: to plead guilty or not guilty, or to stand mute. If you stand mute, a plea of not guilty will be entered. You may plead no contest with the permission of the court. You have the right to have a trial by jury and to have the assistance of an attorney. You have the right to an attorney appointed at public expense if you are indigent, which means without money, and if the offense charge requires a minimum jail sentence or the court determines that it might sentence you to jail. The appointing authority will decide if you are indigent and appoint counsel if you are eligible. You may have to repay the expense of an appointed attorney, You may contest your ability to pay the ordered fees if the court attempts to collect any costs for an attorney, and the court must determine your ability to pay at that time. If you have a trial, you have the following rights: to call witnesses to speak for you at trial. You may get an order signed by the court to require those witnesses to come to court. To see, hear, and question all witnesses against you at trial. To be a witness for yourself or remain silent. If you choose not to be a witness on your own behalf, the prosecuting official may not comment on your refusal to testify. You also have the right to be presumed innocent unless proven guilty beyond a reasonable doubt. If you plead guilty or no contest and your plea is accepted, you will not have a trial of any kind, and you'll be giving up the rights that we just went through. You have the right to be released on bond. If you are now on probation or parole and you enter a plea of guilty or no contest, or a finding of guilt is made by the judge or jury, it may result in a violation of your probation or parole. You can be sentenced to jail and fines plus costs. The court will tell you on the record the name of the offense, the mandatory minimum jail sentence, if any, and the maximum possible penalty for the offense, including jail, fines, or both. Fines, costs, and other financial obligations imposed by the court must be paid at the time of the assessment, except when the court allows otherwise for good cause shown. If you are not able to pay due to financial hardship, contact the court immediately to request a payment alternative. An appeal to the circuit court may be taken within 21 days of the date of sentence or is permitted pursuant to court rule if the sentence includes incarceration, and if you wish to file an appeal but are financially unable to retain a lawyer, the court will appoint a lawyer to represent you on appeal if the request for a lawyer is made within 14 days after sentencing. Federal law and or state law may prohibit you from possessing or purchasing ammunition or a firearm, including a rifle, pistol, or revolver, if you are convicted of a misdemeanor crime of violence and you are a current or former spouse, parent, or guardian of the victim, you share a child in common with the victim, you are or were cohabitating with the victim as a spouse, parent, or guardian, or you are or were involved with the victim in another similar relationship. Ms. Reed, do you understand those rights as I've read them to you?
Yes, I do.
You have the right to be represented by an attorney at all phases throughout this process, and if you could not afford one, one would be appointed to represent you. Today, do you plan to hire an attorney, request the appointment of an attorney, or represent yourself?
I just want to get it over with, Your Honor.
That wasn't my question. My question was, do you wish to represent yourself, hire an attorney, or request the appointment of an attorney?
It doesn't matter. I don't care. I really don't feel good mentally, physically. I really don't.
Ms. Reed, you have one question with three possible answers. Do you want to hire an attorney, represent yourself, or request the appointment of an attorney?
Request an appointment. It doesn't matter. I don't give a shit.
All right,
I don't care. I don't care. I do not feel good. Do you not understand that I do not feel well? Okay, I do not feel good. I don't get like this. I do not feel good. I have not been even seen a nurse yet. I am dizzy. I'm about ready to fall over. My temperature is like way hot. I do not feel good at all. Do you not understand what that means? I can take it for so long and then I cannot feel good. I do not feel well right now. I do not.
Are you quite done? May I continue?
My eyes are burning on my head. What?
The court will make a referral to the public defender's office for the appointment of attorney. We'll set this for a pretrial conference. That is where the attorneys will meet to see if there's a way to resolve the case short of going to trial. You also have the right to have a bond set. Your bond is based upon the probability of you appearing at future court appointments, the seriousness of the offense charged, and the threat that you pose to the public.
Since I've been here.
Historically, the defendant has a retail fraud third, a larceny in a building, another larceny in a building, an attempted forgery, a retail fraud third, and a possession of meth. She attempted to appear on April 10th, and we had technical issues. She failed to appear on the 24th of April, and a show cause was issued. She then failed to appear on the 15th of May, and a bench warrant with a remand was ordered, and that is where we are at today. Mr. Hartel, any comment regarding bond?
Yes, Your Honor. I would ask the court to consider, even though she is lodged, and I know if she's given a PR bond, she won't be getting credit for each day in this file. I don't know everything that's going on in Traverse. I would hate for this file to be the reason why, if she's otherwise able to be released, be it to complete release or release to treatment, whatever the situation is. She mentioned some medical concerns. Maybe Traverse City releases her to a hospital. I don't know. I would like her to be able to do that without us having to file a bond motion here, so we don't slow such things down. If the court could, knowing all that, give her a PR bond, I do believe that would be appropriate based on the totality of the circumstances, the nature of these charges, the fact she's presently lodged, etc. Thank you.
Prosecutor's office.
Thank you, Your Honor. While the defendant is presently lodged, we do not know at this time if she's going to be released from Grand Traverse. And given the repeated failures to appear before this court, we believe that a small monetary bond would be appropriate. It's alleged in this case that the defendant was pulled over for speeding, at which time she advised the officer that pulled her over that she did not have a valid driver's license. Thank you, Your Honor.
I don't know why she's in Grand Traverse County Jail. We tried to get that yesterday and we weren't, she didn't appear to know why she was in the Grand Traverse County Jail. I do know she is on probation out of Grand Traverse County for a meth charge. Given the defendant's multiple fails to appear in this case, I'm going to set bonds at a $500 cash bond, cash assurity. That way she will continue to get credit in this case during the time that she's sitting in Grand Traverse. She is to appear as ordered, keep her contact information current, not leave the state without permission, and to commit no new crimes. Thank you, Grand Traverse. Oh, I am also signing a fingerprint order to have her fingerprints taken. So you will be receiving that as well.
Now, I don't know if you can get much more Gen Z than what happens in this video. Again, sorry for the handheld camera. I had a really busy day, so I'm kind of mobile today. But I just came across this one in Judge Wiggins' court. A cute little 18-year-old, but it seems like she's got a vicious side. She's no little sweetie at all. Really air fryer right now. But anyway, she has done some really nasty stuff, and the judge is not giving her a break. And frankly, I don't think she deserves it at this point. I'm all for young people getting a second chance, but it seems like it's more than a few chances that this lady's had. And of course, in true Gen Z fashion, it ends up on TikTok. It's brutal. Check this out.
The victim is a 14-year-old middle schooler. The victim reported that she had no injuries. It is alleged in the police report that Ms. Jones posted another video on TikTok captioned round 2. And this appeared to be all over some things that were said about another's deceased mother.
Robert Hartzell for Ms. Jones. You can come over here.
We are set for a pretrial conference. It appears we have a resolution in this matter, Mr. Carnes.
Yes, Your Honor. It's my understanding the defendant will be pleading no contest as charged. The people are supporting a delay of sentence with a full dismissal if the defendant is successful on the delay. Success on the delay would be whatever programming is recommended by probation and no violations of typical probation conditions.
Is that a Killebrew?
Yes.
Okay.
And the reason for the no contest plea is potential civil liability, Your Honor.
And so just so we're clear, the success is completion of programming and no violations.
Correct, Your Honor.
Mr. Hartzell?
That is accurate, Your Honor.
Ms. Jones, have you heard what the attorneys have said the resolution in this case is?
Yes.
And is that how you wish to resolve it?
Yes.
Will you please raise your right hand? Do you solemnly swear or affirm that the testimony you give in this matter will be the truth, the whole truth, and nothing but the truth?
Yes.
Ms. Jones, it's my understanding that the agreement today is that you will plead no contest to assault and/or assault and battery. That is a 93-day misdemeanor and/or a fine of $500, and consecutive sentencing may be imposed if the offense happened in a place of confinement. Now, along with that, there's what's called a Killebrew agreement, And what that is the prosecution and your attorney and you have reached an agreement that you'll be placed on a delay of sentence. And if you're successful with that delay of sentence, the case would be dismissed. Success means that you complete all the programming that your probation officer requests that you do, and you not have any violations. Do you understand that?
Yes.
Now, if I decide that I do not want to go along with that agreement, you have the option to withdraw your plea. Do you understand that?
Yes.
Additionally, this is going to be a no contest plea due to potential civil liability. What that means is that the alleged victim in this case could potentially sue you for any damages in which she's incurred. A no contest plea allows me to read a document, looks like it's going to be a police report, and use that police report to determine whether or not there's a factual basis to accept the plea and to use that for sentencing purposes. Do you understand that? Additionally, a no contest plea cannot be used against you. So if you are going to plead guilty and this person sued you, that guilty plea could be used against you. The no contest plea means that it's not. Essentially, you're accepting responsibility without saying that you did it. Do you understand that?
Yeah.
And is that how you wish to proceed?
Yes.
Back on March 31st of this year, were you on probation or parole?
No.
Were you on bond in any other file?
No.
I have this signed advice of rights form in my file, talked about your rights to an attorney and your rights to a trial. Did you read that form?
Yes.
Is that your signature on the bottom?
Yes.
And did you understand those rights?
Yes.
Do you have any questions for me about those rights?
No.
Most importantly, do you understand that by entering a guilty plea or no contest plea today, you'll be giving up those rights and you won't have a trial of any kind? Do you understand that? I need you to speak right up.
Yes.
Everything we say is recorded, so I need to make sure the recording equipment's getting used. Ms. Jones, has anybody promised you anything other than a plea agreement in order to get you to plea today?
No.
And has anybody threatened you in any way in order to get you to plea?
No.
And is it your own free choice to plea today?
Yes.
Are counsel aware of any other promises, threats, or inducements which have not been made part of the record?
No, Your Honor.
No, Your Honor.
Then Ms. Jones, to the offense that on or about March 31st, 2025, here in the city of Cadillac of Wexford County, how do you plead to committing the offense of assault and or assault and battery upon Courtney Elaine Whaley?
No contest.
Counsel, I've been provided with a Cadillac Police Department report, incident number 250000819. It's been marked as People's Exhibit number 1. Mr. Carnes, do you move for its submission?
Yes, Your Honor.
Mr. Hartel?
Yes, Your Honor.
No objection then. The People's Exhibit number 1 is received. Give me just a moment to review that. Here we are back on the record. I've had the opportunity to review the People's Exhibit number 1. Do counsel believe that it forms a factual basis in which to accept the plea and that the court rules have been complied with?
Yes, Your Honor.
Yes, Your Honor.
As does the court. I find the plea is knowing, voluntary, and accurate. As such, Ms. Jones, I find you guilty of assault and or assault and battery. In particular, on March 31st, 2025, there is a video that shows Ms. Jones hitting, kicking, kneeing as the victim is lying in a fetal position by the old, what's commonly referred to as the old dam. The court can take judicial notice that is located here in the city of Cadillac and is between Haynes Street and River or Wright Street on the what's now known as something along the lines of the Green Trail or the Green Pathway. The victim is a 14-year-old middle schooler. The victim reported that she had no injuries. It is alleged in the police report that Ms. Jones posted another video on TikTok captioned round 2. And this appeared to be all over some things that were said about another's deceased mother. As such, I find that the elements are made out for an assault and battery, and that this would have been an unwanted, forceful, violent touching. Additionally, I believe the interests of justice are well established here in allowing the defendant to plead a no contest so as to not have her guilty plea used against her should a case of civil liability arise. Although I question what the civil liability would be since there's no injuries, but I guess that's not for me to determine. Mr. Carnes, are we able to sentence today?
Yes, Your Honor.
Mr. Hartel, any allocution?
Yes, thank you, Your Honor. Anytime it's no contest, especially for civil liability, I'm cautious to overly allocute for obvious reasons. But what I will say is my client has, to my knowledge, done well on bond. She stayed in constant contact with the defender's office, been very cooperative. She does have strong ties to the community. I don't doubt she'll do well on probation. She's highly motivated to do well and receive the benefit of the delay. I, in these situations, always advise my clients, if they don't do well, there is the risk of jail later, the loss of the delay, the public adult record. She's a relatively young adult. She wants to be able to pursue various careers and ambitions. At the moment, she's working at Qdoba. She's aware she owes some money on some older files, but she is going to, I believe, do a wage assignment, if I understand that correctly. She also has some friends with her in the courtroom who've been supportive throughout these procedures, and I don't doubt will continue to be supportive of her as well. I ask the court to uphold the guilty plea. Thank you.
Carnes?
Thank you, Your Honor. This is a disturbing incident involving defendant and a 14-year-old. Clearly shows some lack of judgment, lack of maturity. However, the defendant does not have any prior convictions. I think ultimately this is a fair resolution of the file. I'd ask the court to place Ms. Jones on a delay of sentence of up to 8
Mr. Carnes, I know the CCH is relatively blank because she's just now 18, but there's some juvenile history, is there not?
Your Honor, I don't show that on Wayne. And I am familiar with Ms. Jones on some other things, but not where she was the defendant. So if the court has.
Well, I'm just trying to remember. I remember, seems like climbing on top of the school for the 4th of July. Were there charges on that?
She moved when she was 18. That was resolved with a civil infraction, I believe. I'm just going purely off memory, Your Honor.
I'm going to be very honest with everybody. I don't plan on following this Killebrew agreement. She's an 18-year-old who literally kicked and beat a 14-year-old in a fetal position on the ground because of something that was said about somebody else's deceased mother, and then had the gall to post another video of it on TikTok. That's not somebody who's making a mistake. That's not what this type of thing is designed for. A delay of sentence is to allow the court to determine whether or not the person will be successful on a term of delay in sentence, and hopefully follow through with the plans. From what I've seen from Ms. Jones and Mr. Carnes, if you tell me that charges weren't brought, I trust you on that. But I can tell you, and I'm not using any of my prior knowledge because clearly it's not full, but I do know from my time as the elected prosecutor here and as judge, and I believe she has another case coming up that she has to be arraigned on with Judge Van Oltz, because I had a conflict on that because I was the elected prosecutor when that was arose. This is not a one-time mistake. Ms. Jones has been in and out of this, whether it's this court or the probate court, or somehow tied with other events. I'm not going to make a decision today. What I'm going to do is I'm going to set this over for sentencing, and I'll allow both parties the opportunity to do sentencing memorandums and try to convince me why I'm wrong in my thought process. But as I sit here today with the information I have, I cannot in good conscience let this just get, for all intent and purposes, swept under the rug. But as I said, I will allow the opportunity for some briefing or some sentencing memorandums to be done. And I realize, Ms. Jones, I had not given you the opportunity to allocute yet, but we will adjourn sentencing and allow that to happen. Ms. Jones, your bond conditions continue.